How you doing? Welcome back to Ask the Patent Attorney here at patenthome.com. My name is Nate Lewinsky, and I'm sitting here with
Ben Latempio, registered patent attorney.
Klaus, Stanger, and Latempio out of Buffalo, New York, and one of the authors of Patent Fundamentals for Scientists and Engineers, and one of the curators here at patenthome.com, which falls under Klaus, Stanger, and Latempio. And we've been moving along here, talking about the patent process, talking about the different types of patents. We're talking about design, we're talking about utility, we're talking about the different types of utility patents, talking about the prior art search and what you got to do to get there. But what we wanted to start off with today...
You're becoming a regular expert yourself there, Nate.
Right. It's almost as if we did a few of these right in a row. Well, anyway, what we want to talk to you about today is that the landscape for obtaining a patent and the patent laws are going to be manipulated a little bit in the next year. And Vin, why don't you talk a little bit about that?
Well, the biggest thing that's going to happen in March of 2013, it's going to be the first inventor to file. Now, right now, the way the law is the first person who invents something, regardless if they're the first person to file. And so, in other words, if you invented something today, and I independently from you came up with the same idea 2 months from now, and I file it right away, and then it takes you 3 months to file it, you can still petition the patent office in an interference proceeding, and you can say, "Hey, I invented it first. I'm the first inventor.
I have to prove it. I have to prove it. Obviously."
Well, yeah, they have what's known as a swearing back document. You can show through your laboratory notebook, through your witnessed, signed witnessed.
Could have even been used in business, maybe. Or I have a picture of it.
Whatever proof. It's going to be an argument to who invented it first. But if you can prove that you invented it first, even though somebody else filed it before you, you can get the patent. Well, the laws are going to change, so whoever gets to the patent office, it's going to be a race. Whoever files it first wins. All he has to do is prove that he's the inventor. Now, what they're going to have, the new law calls for something called a derivation proceeding. Derivation means I derived it from you. So maybe I was working at your factory that you owned, and I quit, and then I raced out and I filed it first. And then you could say, well, wait a minute, he derived it from me while he was working there. I taught him how to do it, and I taught him how to make this, and he got this idea from me. If he got this idea independently on his own, and he got it 3 months after I came up with it, because he beat me to the patent office, he would win the race.
But what if I proved, or what if you proved that my idea had come from you? If I derived it from you, then what? What happens?
Well, then
there?
It becomes mine. Then I stop,
you stop me. Okay, so it's not completely unfair. Is what you're saying.
Well, what do you mean? Why do you think it's unfair?
Well, it seems that the race to the patent office, it's almost like you had Nancy Kerrigan their leg, and you just run there first. You got it in your hand, like.
Well, and that's the problem.
That's how it feels.
And that's why the little people, the small independent inventors feels this favors the big business. And the whole idea of the patent reform is to, make everything work smoothly, let the office work, and better. But a big reason why they're doing it, I think, is just to get in tune with the rest of the world. Pretty much every country in the world does it that way right now.
Oh, okay.
So I guess the best advice for the little guy, don't tell anybody your idea and get there as fast as you can and file it.
Right. Mum's the word.
Even though the rule, and we talked about it, I think in the last episode, we'll go over it real quick right now, is 102B basically says that if somebody offers it for sale, uses it in public, or publishes it, they have 1 year to file the patent application. Now, it gives you that 1 year to go out there and try to work it up and file it, especially because you're the first inventor. But now if you use it out in public, I guess this isn't real. They're not really the inventor if they see it from you, but how are you going to prove that?
Right.
So you're probably better off. And the same thing right now, I give the same advice to inventors. Don't tell anybody your idea. Let's get it filed as soon as possible. And there's different ways to get it filed as soon as possible. And we were talking about that earlier.
Well, another thing I wanted to ask you, too, is, someone might not be, and this is why we encourage everyone to give you a call. You need to get a patent. That's what you want to tell them. Everything I've talked to you about, it feels like if I'm an inventor, I need to get a patent. I'm not just going to take my great idea and start doing business with it. because that's not going to be enough, especially come next year.
Well, again, we talked about this in an earlier episode, and everything kind of comes back together. Is that you get to stop others from using your idea. It doesn't give you a right to make it. It gives you a right to stop others. But what I was talking about was different ways to be the first person to race to the patent office. And when we're talking about the big companies having the advantage because they have all this money and they can afford to file applications, there's another tool. There's a provisional and a non-provisional patent application that allows the smaller inventors for a lower amount of money to preserve their idea with the patent office.
Right, and is that one of those things? I mean, you look on the bottom of the box, or you get a piece of. You buy a new thing and it says patent pending.
Patent pending, yeah, and that's basically it. From the moment you file your patent application, your patent pending, so you can go out there and try to market your idea, and you could basically say, I filed a patent application. So let's go back to what we're talking about, the provisional and the non-provisional. There's a thing in the U.S. Patent and Trademark Office called the provisional patent application. Now, the provisional patent application never becomes a patent. It never matures into a patent. But what it does, it preserves your filing date. So if there's a race to the patent office, you can say that I filed it on this date. Now, from the time that you filed it, say we filed it today,
sure,
you have 1 year to file your non-provisional. Now, the provisional patent application allows you to file it without claims, without any of the formalities of the non-provisional. You don't need the fancy smancy drawings, but you just need enough information in there to identify what your invention is. So when you file your non-provisional within the year, you can say it's based on this application and it has all the elements necessary to describe your invention in there. So the question now becomes, why is it better for an inventor to do that? Well, the little guy doesn't have the money, and it's less expensive. There's a 500 and change. I think it's 550 or 530 right now to file the non-provisional. To file the provisional, it's right around $100.
Right.
So just on the government fees, it's less. Now, if there's not so many formalities to file it, there's not as much work for the patent attorney to do. So it'll be cheaper for a patent attorney to file the non-provisional because the patent attorney is going to charge you based on the complexity and the time it takes to put it into it to make it to work it up to a patent application. And if you're filing a provisional patent application, you could probably do it in a lot less time because you don't have to have as much detail and as much descriptive. You still got to describe it where you understand it, but you don't have to follow all the formalities of the patent office. So you could probably file it for a lot cheaper. So they'll give you an opportunity to preserve your filing date, and you have a year or so to go about trying to market that idea.
Okay, and that was actually the question I was going to ask next. In your experience, have you seen where I'm an inventor, I'm a single person, I'm a single entity, sole inventor, and I we do the prior art, we go for the provisional, I only have so much money, I'm trying to just sort of piece it together, and then I try to market my idea to some people who invest and help me push that patent process along. Like, I need to get some extra money. Can I use that? Now I have you said I can start to market my idea, start to use it in the marketplace.
Well, in theory, yes, but you know how life is. That year just flies by, and before you know it, the year's over and it's time to file. And yes, I've seen inventors come back and say, yeah, I got some leads. I think things are moving towards it. I even got some guys come back and say, I've got $1 million of offers. That's happened, yes, but you really got to put the pedal to the metal and really go after it, because that year, baby, it just flies by.
Now, what was I going to say? Now, okay, so I spend the money. Now, provisional patent, what is the money for that? Does it get rolled into the final, or does that?
Well, yes, it does to an extent. I mean, you still have to file the non-provisional, but the way I do it is I get that non-provisional or that provisional in pretty good shape. So when it comes time to file the non-provisional, we get most of the work done. But you know what? After that year goes by, and we still have to do the drawings, and we have to still design it. So it ends up in the long run costing more, in the short run costing less, because essentially what it just gives you a chance to freeze the clock, get your filing date in, and gives you a year to go out there and
get all this stuff.
See if you're going anywhere with it. And so a lot of people say, oh, let me just get the non-provisional, get it out of the way and finish it right now, bite the bullet and get it done. But it does give, those an opportunity that don't have that big chunk of cash up front to spend a smaller amount and get the thing rolling and preserve your date and to get out there and try to sell it.
Yeah, so if I'm real antsy and I want to just lock this down real quick, and it's November, and I'm just going to wait till I get my tax return so I can do the rest of the patent. Then I guess I'll just do that non-provisional now and say, okay, I'm going to plant this seed now, and we'll harvest there in the springtime or whatever happens.
Absolutely.
Well, that was some good information, Vin. I appreciate your time, and I appreciate you checking us out. Now, try to get to the email and to the website. There's some more detailed information about all this stuff on the resource page on the website and all the videos.
Yeah, or just give me a call. The 1-800 number goes right to my cell phone. I actually have my cell phone on a couple of these videos.
Right.
I was thinking maybe I'll put 800 number on some. The other one, we kind of, this is kind of a new thing for me too. The YouTube and all this stuff on the internet, but I'm enjoying it. I'm having fun with it. Thank you, Nate, for helping me out.
And we want you to know that you're talking when you're going to give Patent Home a call, you're going to be getting Vin right away, direct. And whether you're ready to file or you just got your idea, just germinating the idea in your head, you give a call, you find out where you stand, and you're going to be better for it. PatentHome.com, ask the patent attorney, and we'll look forward to you checking us out next time. Thank you.
Thank you.